Hello, this is Ohio landlord attorney Jonathan Schlegel. I'm here to discuss what to expect when you have an eviction hearing as a landlord. If this is your first time, I want you to know you don't have to be intimidated by eviction court. It's not Suits, it's not Law and Order. The court is pretty casual, so non-lawyers can handle it without an attorney some of the time. For a basic eviction hearing in most courts in Ohio, although all courts are pretty similar, they all have a little bit of nuance to them, a few differences here, a few differences there. But for most courts in Ohio, or at least the major ones, Cleveland, Cincinnati, Columbus, Dayton, when you are supposed to arrive in court, there will be a number of cases all assigned at the same time. You won't know when your case is going to be called. It might be first, it might be last, somewhere in the middle most likely. You need to wait for your case to get called, and you need to be prepared to answer some questions. If you don't have an attorney, the judge is most likely going to ask you these questions. And here's the basic format for how this is going to go. First thing the court's going to do is they're going to swear you in. You're going to raise your right hand, and they're going to ask you if you swear to tell the truth, the whole truth, and nothing but the truth. You're going to say, I do, and then they're going to proceed from there. If the tenant shows up, don't worry about it. Your case is pretty much the same. The way this is going to work is the judge is going to start with you because you're the plaintiff and you need to prove your case. Judge is going to ask you some basic questions. First question is going to be state your name for the record. You're going to tell him your name. And he's going to ask you, do you own the property at whatever address the rental is? And you're going to say, yeah. If you own it jointly with your spouse, no problem. You can say, yeah, I own the property with my wife. That's fine. If you own the property in an LLC, or if it's in a trust, you own it in a corporation, if you're doing this on behalf of a family member with a power of attorney, that sort of thing, you are going to need an attorney in Ohio. Otherwise, you're doing what's called the unauthorized practice of law. At any rate, the court will ask you, do you own the property? I do. Or I own it with my wife or my husband. Do you rent to the defendant, to so-and-so, pursuant to a written lease agreement? Most of the time, the answer is yes. Sometimes the answer is no. Sometimes this is an acquaintance that lives in the property, and you let him move in and say, hey, pay me $500 a month in rent, or something like that. And that's fine too. You just tell the court the truth, whichever it is. Or do you rent to the defendant pursuant to a written lease agreement, oral lease agreement? Yes, I do. Pursuant to that agreement, is the tenant obligated to pay rent each and every month? Yes, they are. Most of the time they are. You generally don't rent to somebody for free. If you have a different case or if you have a different situation, you might need to talk to an attorney about it. But most of the time, your answer is yes, they're supposed to pay rent each and every month. And the court's going to ask you, did they fail to pay rent? What does that mean? That means did they stop paying you rent? Most of the time, the answer is yes. Why are you here? That's why you're here, because they stopped paying you rent. So you're going to say, yeah, they failed to pay me rent. And the court's going to ask you, because of that failure, did that cause you to serve this 3-day notice? Presumably, you filed that 3-day notice with your original eviction complaint. It's required by most courts in Ohio. Filed that 3-day notice, and the court's going to say, is this a copy of the 3-day notice? You're going to say, yeah. And they're going to say, how'd you serve it? And you're hopefully going to say, I taped it to the door. In Ohio, you got to tape it to the door. You can send it certified mail. You can hand it to them personally. You don't want to mail it to them by regular mail. You don't want to email it to them or text it to them. You want to taping it to the door is a surefire way to do it. Tape it to the door, take a picture. That's the end of it. Tell the court, I taped it to the door. The court's going to ask you, were they behind on rent that day? The answer is yeah, they were. And then they're going to ask you, are they still behind on rent today? Yeah, they are. And they're going to say, when was the last time they paid rent? That answer better be the month before you tape the 3-day notice to the door or before that. You don't want to take rent in a month and also pursue an eviction in the same month. One or the other. You don't get to take the money and pursue an eviction. When was the last time they paid rent? Sometime before the 3-day notice, not the same month. Are they still behind on rent today? They are. How far behind on rent are they? Hopefully the answer is 1 month, 2 months, 3 months. If it's 8, 9 months, you might have yourself a problem. You might want to call an attorney. That can raise some defenses for the tenant, so you need to act quickly. When you have a problem with a tenant, it's best not to let things linger. You need to go and exercise your rights as a landlord. How far behind are they on the rent? 1 month, 2 months, 3 months, whatever the answer is. Are they still residing in the property? Yeah, that's why you're evicting them. If they weren't residing there, you wouldn't be in the court. The court wants to ask that question because sometimes tenants move out before the court date. And their follow-up question is going to be, when was the last time you checked? Last time you checked should be sometime in the past couple days, 3 or 4 or 5 days ago. You don't want to say, I checked 2 weeks ago, because tenants move out when they're being evicted a lot of times. If the court hears, I haven't checked for 2 weeks, the court's going to say, well, come back next week. Let's do this all over again. And why don't you check to see if the tenant's actually out of the property or not? Assuming you've checked in the past couple of days, they say, when was the last time you checked for occupancy? Say 3 days ago. Great. And then they're going to ask you, are you asking the court for possession of the property to be returned to you? Of course, that's why you're here. The answer is yes. And then they'll say, great, no further questions. Judgment for the plaintiff. That's you. And you're going to win the case. Got any questions about that? Ask me in the comments. Happy to help you out. Subscribe and see you on the next one. Bye-bye.